Tonight on The ReidOut.
So help me God.
So help me God.
Now, on behalf of all of the members of the court, I am pleased to welcome Justice Jackson to the court and to our common calling.
An historic transition coming at the end of the most activist and, frankly, destructive Supreme Court terms in more than a century. Also tonight, more criminal exposure for Trump and his January 6th enablers, including a potential criminal referral for witness tampering. But we begin tonight with a look back at what has been one of the most consequential and life-changing Supreme Court terms since the courts that overturned segregation and expanded women's rights. Only this court has done it all in reverse. Today was the last day that we heard from them this term, and actually, thank God. Because in the past month, the conservative majority has successfully weakened Miranda rights, kneecapped state gun safety laws, betrayed indigenous sovereignty, begun to dismantle the separation of church and state, and curtailed women's rights to privacy and liberty. And that was all before today, when in one of the court's final rulings this term, the 6-3 conservative majority effectively gutted the EPA's power to regulate greenhouse gas emissions from power plants that contribute to global warming. Yep, at a time when the climate catastrophe is giving us a collective beatdown, when the UN recently warning that we need to do something, not now, but right now, the court struck down this regulation that the EPA drafted under authority granted by the Clean Air Act, claiming that it amounts to an extraordinary overreach by the EPA. The decision will not only have major implications for the survivability of this planet, but it will also affect how the federal government more broadly can implement any regulations going forward. Emboldened by the ruling, the chief plaintiff, the Republican Attorney General in West Virginia, Joe Manchin country, warned that they were just getting started. Coal in everyone's stocking this Christmas. This year's rulings really should not come as a surprise. They are the culmination of roughly a half-century's worth of work by conservative politicians looking to remake the federal judiciary system after a period of what they viewed as radical progressivism. Now, make no mistake, these justices who swore under oath that they had no political opinions have proven that they very much do have a political agenda. And it all began back in 1991 with the contentious confirmation hearing of Justice Clarence Thomas after surviving credible claims of sexual harassment and a bruising confirmation hearing. Justice Thomas made clear that he had an agenda and was ready for retribution. Back in 1993, the New York Times reported that Justice Thomas told 2 law clerks that he wanted to remain on the court until 2034. When they asked why, he reportedly said, "The liberals made my life miserable for 43 years, and I'm going to make their lives miserable for 43 years. And if you had any doubt that he had an axe to grind, his wife, the active insurrectionist, told People magazine that he doesn't owe any of the groups who opposed him anything. In the year 2000, Thomas was part of the 5-4 majority that took the extraordinary step of putting a stop to a Florida recount, effectively ending former Vice President Al Gore's presidential aspirations and putting the Republican majority on the court's preferred candidate in the White House. Thomas is now the senior member of a group of conservative justices who now join his once extreme views, and who also played a role in that Florida case. Justice Brett Kavanaugh and Amy Coney Barrett and Chief Justice John Roberts were all part of a team that was working for the Republicans during the recount battles in Florida, which culminated in the historic Supreme Court decision that the court majority was so embarrassed about. They wrote down that it should never be used as a precedent. Well, the embarrassment is gone. This summer, the conservative majority delivered yet another set of victories for the Republican Party and its ruling evangelical wing. During his confirmation hearing, Chief Justice Roberts famously said that his job was to call balls and strikes and not to pitch or bat. Well, it is clear that 5 of his colleagues do not ascribe to that policy because they are very much knocking balls out of the park for one team. Gone is the concept of judicial restraint, and in its place is the made-up conservative philosophy of originalism. According to the Washington Post, taken together as a whole, the decisions mark, for now, the triumph of originalism, a radically conservative judicial philosophy that maintains that the only legitimate way to decide constitutional disputes is to ask how they would have been resolved when the Constitution was drafted. At a time when no one except land-owning white males had any rights at all, and when women weren't even mentioned in the Constitution. Now, unfortunately, you should probably brace yourselves for more, because they are not done. This morning, the court agreed to hear a case on whether state legislatures should be immune from judicial oversight in state court when it comes to setting election rules. Republicans in North Carolina want the court to grant state legislatures immutable authority to gerrymander electoral maps and to pass voter suppression laws or to make voting rules without their state Supreme Courts being able to intervene or weigh in. In other words, the right to do exactly what Donald Trump wanted swing states to do as part of his January 6th coup attempt, just in time for 2024. And no, do not expect Clarence, husband of insurrectionist Ginny, to recuse. Joining me now is Erin Carmone, senior correspondent for New York Magazine. And Erin, it is good to see you, my friend. It has been too long. I know you wrote the very excellent hit book, The Notorious RBG. So you've been paying attention to the court for a long time. This court's radicalism, I think, is striking some people as a shock. I'm not sure why, but did it shock you?
Well, I mean, I think it's important to remember that Justice Ginsburg became the Notorious RBG. She earned that nickname by dissenting from conservative opinions, including the gutting of the Voting Rights Act. And so this is a direction that the court has been moving in. As you very well laid out, there was an aberration in the court's history of protecting powerful people, of upholding slavery, of blocking women's rights in the second half of the 20th century. And that is what has empowered this conservative legal movement. I think the difference that we're feeling now is the speed and the brazenness. So John Roberts, Chief Justice John Roberts, I think, has a kind of savvy PR approach to how he chooses to do this. He usually likes to do at least 2 cases before he guts a major precedent so that he can then say, look, we did this before. He'll take a half step. He did this with the Voting Rights Act. He's done it with many other cases. He'll occasionally show his independence from the Republican Party, particularly when the Trump administration got really sloppy on certain issues. And that allowed people to still think that in decisions like Obergefell, with Anthony Kennedy joining the liberals, some abortion rights opinions that weren't as bad as they could have been. For a while, there was sort of a treading water. But I think you're right to place it at Bush v. Gore. Clarence Thomas, when he joined the Supreme Court, he was the minority ideologically. And I think that Bush v. Gore put the Supreme Court on a path for Clarence Thomas to be the intellectual vanguard leading the way, such that Brett Kavanaugh is now the median justice. Again, one of this team in Bush v. Gore. And I think one way to measure how much things have changed is that when Justice Ginsburg dissented in Bush v. Gore, a lot was made of the fact that she didn't say, I respectfully dissent. She just said, I dissent. And that was considered, wow, really calling out her colleagues. Listen to the dissenting justices now. And I should say, congratulations, Justice Ketanji Brown Jackson, and also I am very, very sorry, because she is about to join these ranks of the losers whose job it is to lay out very clearly in pages that the Supreme Court justices themselves can't ignore what's happened. And so here's Justice Kagan today in the EPA decision. She says, the current court is textualist only when being so suits it. When that method would frustrate broader goals, special canons like the major questions doctrine, this is something that they totally made up, that came to light in the EPA case and also in this case that's coming up with the legislatures, magically appear as get-out-of-text free cards. Now, that's pretty out there, and they were also pretty out there in the Roe decision. These institutionalist liberals that sit on the Supreme Court are actually warning us that as bad as things have been, they are getting worse really, really fast. And as you mentioned, they're about to get worse for maybe as long as our lifetime, considering the age of these justices on the court now.
And the thing is that, you go to Kavanaugh. I mean, this is somebody whose memorable quote is what goes around comes around, other than I like beer, in that he essentially was threatening that, that he's saying, I am going to politicize this court. Alito was pretty brazen in saying, no, we're a court that has desired outcomes. We're going to rule almost always in favor of conservative Christians, whatever they want. They're ruling at this point, they're 83%, whatever conservative Christians want, not religion. Just conservative Christians. I haven't seen them do that for Muslims. I haven't seen them do that for any other religion, for Jewish people. Just conservative Christians. Just they're down the line. For corporations, for wealthy people. They're pretty doctrinaire. The brazenness, I think, is what's new. They're not hiding the fact that they are an evangelical-minded pro-conservative Christian and pro-Republican group. I think Bush v. Gore unleashed that too. Do you?
I do, absolutely. And I think it also, they've had a series of strategic plans that have gotten them to this point. They've also gotten lucky in terms of both deaths and retirements on the Supreme Court. The fact that so many conservatives galvanized and there was no punishment for Mitch McConnell or Donald Trump. In fact, it helped Donald Trump that Scalia's seat was left open despite the norms. It turns out that so many of the things that govern the Supreme Court were actually sort of soft norms and politeness, and that there were enough Republican appointees that were willing to follow the rules and believe in the institution of the court. But there was nothing really holding them except for some measure of political accountability. The moment Trump wins in 2016, that gives us Gorsuch, that gives us Kavanaugh, and wow, listening to Clarence Thomas talk about his feelings of vengeance and then have them be paralleled by Brett Kavanaugh, when both of them have been accused credibly of sexual harassment and attempted rape. I think it shows you that we are reaping the whirlwind right now, and we're going to continue to.